So today the New York Post was kind enough to feature my recent verdict on the cover of their newspaper. And I did obtain a verdict on behalf of my client who was traumatically injured and suffered an amputation of his leg when he was run over by a subway train. Now the headline by the Post puts an interesting slant on it. They call it lush money and they call my client a drunk. But what really happened was that he was 22 years old at the time of the accident, out having beer with some friends. And while he did have a level of intoxication, he didn't know how he ended up on the tracks. And there were no witnesses. He could have passed out or fallen asleep or slipped. But even if he did stumble on the tracks as a result of being intoxicated, the transit authority is still responsible. And that's the bottom line, and that's why we won the case. The transit authority, by their own experts, have rules that require a train operator to stop a train if that train operator sees a person on the tracks or even a big mass and they don't even know if it's a person. If there's a mass on the tracks and a train operator has time to stop the train, they are obligated to do so. And if they don't, that's negligence. And in this case, the train operator himself testified at a pretrial hearing under a sworn oath that he saw something on the tracks. It appeared to be a mass. He saw it from over half a football field away, and he didn't stop the train. And he said he could have if he chose to at that time. But he thought it was garbage, and he just kept going. He was being lazy. And as a result of his laziness, he caused this horrible accident that could have been prevented. And look, even though the Post is slanting it, a drunk guy, and how dare he collect money for his own fault, the reality, and is what was explained and heard at the trial, is that train operators know people fall on the tracks. They know people get drunk and take the train home and fall on the tracks. They know people get on the tracks for various reasons, and it doesn't give them a free pass. Whether or not he was intoxicated is not the issue. The issue is whether the train operator saw him and could have stopped, and he could have. That's why we won the case. The money that the jury awarded gets reduced because they did find him as a result of being intoxicated, our client, partially at fault, so it does get slightly reduced. But the money that they awarded, a total of $3.5 million, is not outrageous for a 22-year-old man who lost his leg and will require over $1.5 million in medical expenses for the rest of his life for his prosthetic foot and leg to be maintained. So that's my case. I hope you found it to be interesting. Please let me know and submit your comments below, or give me a call or email me if you'd like to discuss the case further.